Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not for legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is Employment-Based Green Cards Part 5, I-485. Before we begin the knowledge session, along with the news updates and latest immigration followed by Q&A, and before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello, Ms. Reddy. Before we get to the topic, do we have any latest immigration updates this week?
Hi, Tony. It's a pleasure as always to be on this show. And with reference to immigration updates, let's see. Yes, I have something for you today. The much awaited litigation on H4 EAD has come to some kind of a conclusion. It's not the best possible result, but it's a good result. So basically, the court has agreed to, in a settlement agreement, has agreed that when H4 EAD is pending, and when it's filed and it's pending, as we know, just to give you a little background, H4 EAD extensions are taking sometimes a year, sometimes 12 months. So, and you can only file 6 months in advance. So effectively what's happening is those people who have H4 EADs are losing their jobs because they cannot work while their EAD is pending, if it has expired. So what they're doing now is, as per the settlement agreement, they are going to be reissuing new receipts, and the receipts will act as if you have an EAD approval. So the EAD will be extended artificially until the date that your H4 I-94 is valid. So say you applied for an EAD, because your EAD expired, but your H4 I-94 I-797 is still valid. So say it's valid for a year, your EAD automatically gets extended for a year while it's pending. So basically what you need to have is a receipt to show that you've applied for H4 EAD, and you need to show your I-94 to show that you have remaining time left on H4 status. Now the catch for this is that oftentimes the H4 EAD and I-94 expire at the same time. So people are generally filing H4 extensions and EAD extensions at the same time, which means that you will not be able to make use of this rule if both are expiring and need to be renewed at the same time, because you don't have an I-94 which is still valid. That has expired as well. The only saving grace in this situation could be if the H4s, the I-539s are usually getting approved faster than EADs. So once that gets approved, you can then, even though the EAD is not yet approved, you can get an artificial extension on your EAD, which will allow you to work. So some good news, at least something is better than nothing. I wish they would just, extend the EADs for the duration that it's pending, But then, some people might say you can't do that because if the H4 has expired, then there's no basis to get a H4 EAD. So that's
Right.
the dilemma that they're in. With reference to the L2s, this has been something that is long awaited. But basically, as per statute, the reading of the statute, L2 really doesn't need a EAD application, but USCIS has been insisting on EAD application for L2. So now they're saying, rightfully so, that an EAD application, meaning an I-765, is not needed for an L2. Being on an L2 itself means that you're work authorized. So you don't need to get an approval separately. So that's good news for L2 people as well. So that's the update that I have, most important update that I have for this week.
Right. Right, Ms. Reddy. So now that you've given all our viewers the updates, we'll move on to a topic which is the I-485 continuation of last week. So continuing the questions from last week, is an interview required for an I-485, Ms. Reddy?
Well, it depends on what USCIS says. If USCIS says it's required, then it's required. If USCIS says it's not required, then 485 could get approved without an interview. It's not compulsory. It's not like when you're filing family-based cases, an interview is compulsory. They don't approve cases without an interview. For employment-based 485s, it really depends on the officer. It's discretionary. So, you could be called in for an interview if there's some issues with your status, or say you've been arrested, and they want to find out, the details of the arrest, or, if there's some issue with your employer in the past, then they want to make sure that you're actually working for that employer and it's not, a frivolous application, and that you're actually working, which client you're working for, etc., etc. I mean, depending if you're in an IT company, then the issue of client comes up. But, they want to make sure it's a bona fide offer of employment. So, yeah, it really depends on the discretion of the officer and USCIS. Of course, sometimes, depending on whether they're being more stricter or they're being less strict, sometimes they have more interviews. And again, it's all politics, also depends on which administration is in power and, whether they're closing the gates or partially closing them or opening them. When everything becomes stricter, then they insist on 485 interviews. Otherwise, it's just discretionary. It depends on, it's on a case-by-case basis. But most cases get approved without an interview.
Right, right. So, Ms. Reddy, what documents should one person, take to the interview?
If you're interviewed, so then you'll get an interview notice in which, at least some of the documents are detailed. They'll ask you to bring your passport, maybe your tax returns, your medicals if you have not already submitted them or if they have expired. They could ask for your pay stubs. They could ask for an updated employment letter, which they may not ask for if you already have submitted a 485J. And they will, generally ask you to bring your original birth certificates if you're married, marriage certificates if you have children, then birth certificates of the children. In addition to that, you just want to carry a copy of your entire file, so that if they're missing any documents, you can, supplement the file with the copy that you have. And you want to take originals wherever you can, so that in case they ask for it, you can show them the originals. They don't take the originals; they just look at them and then give it back to you.
Right.
If you have an arrest warrant, then you want to take certified copies of your arrest. If you have already been convicted or been discharged, found not guilty in any crime, then you want to take the judge's order from the judge, and that is generally they always ask for a certified copy or the original of the judgment.
Right. So, Mr. Reddy, we have a caller on hold, Mr. Kumar from Chicago. Thank you for calling, Mr. Kumar. You may ask Mr. Reddy your question directly.
Hi, ma'am. My name is Kumar. So I have a question. This is for my wife. So we applied 765, I-31, and 485, and my date is not current yet. So my wife I-765 got approved, but I-131 got denied. That is due to the denial letter says that when my wife admitted into the US, it shows like a fraud and misrepresentation. That is the sentence I used in the denial letter. When I noticed that during the DS 160 form, while I'm filling that form, I have a human typo error in that, on my surname, the principal applicant surname, and that got carried over in the visa stamping. So with the same visa stamp, she entered the US, and I'm guessing that is the only reason that fraud and misrepresentation. So just I want some advice on that, please.
I think it's important that you actually email me the notice, or contact an attorney where you can email the notice to the attorney and take a consultation, because it's important to look at the document to discuss this with you further, because this is a little unusual that an advance parole should be denied, and that they should say the reason for denial is fraud while entry into the US, and then all the other applications also should be denied, because if you entered unlawfully, then what is your status, right? So it seems a little weird. There's a disconnect there. So we need to, I think, look at it more carefully. And if they have not given the reason, you're saying they've given the reason, or you're presuming the reason?
So they gave the denial notice. In that they mentioned that due to the mispresentation and the fraud while admitting into the US during the last arrival, that is the reason. And other than that, I don't have any reason.
Did they give the exact reason? So they didn't give a reason.
Yeah, but same thing, like today only my wife got 765 approved. I got card delivered.
Yeah, exactly. That makes no sense. Simply a typo. I think this should be investigated further, and you should file an appeal just to make sure that the record is clear, and submit an affidavit from your wife with reference to.
I reached to congressman, and they also double checked with them, and the supervisor from the congressman, from the visa center, they said it is due to the fraud and misrepresentation. You need to contact with the attorney.
Right. Yeah, the congressman may not be able to do anything, so you need to, I think, file an appeal to that I-131, giving valid reasons and giving your side of the story, because they haven't given you enough information. How can they deny the case without giving you a chance to explain or, rebut? They should have sent a notice of intent to deny instead of sending a denial. So you should definitely appeal that case, and just to find out at least what the issue is. Right. Or maybe contact CBP over the phone to find out if they can give you any further information.
All right. Thank you.
You're welcome. Good luck.
Right. I hope that answered your question, Kumar. And so moving on to our next question, Ms. Reddy. What kind of questions are asked in the interview for an I-485?
Right. So it really, if it's an employment based, and we're talking about employment based, then they will ask you the general questions that they ask all 485 adjustment cases, whether it be family based, employment based, diversity, whatever it is. So they will ask you, basically they're going to go through the form 485 with you. So it's important that you go through the form first, especially if your attorney has filled it out, to make sure you're familiar with what's been written in the form, and so you might have forgotten when you filed it. So go through that again. If there are any typos, you can always get it corrected at the interview itself. They will ask you what your name is, of course, when you last entered, your date of birth. And they'll ask you the other questions from the 485, which talk about, any wrongdoing. Have you done, there are a whole bunch of questions in the 485 form, which talk about illegal activities or immigration violations, or so arrests, etc., etc. So they'll ask you all those questions under oath, so you have to answer them. Make sure you listen to the question first. Don't just blindly say no, 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 or yes, yes, yes to everything. If you don't understand the question, make sure you ask until you understand. Don't answer anything unless you don't understand it. If you don't understand it. So they'll ask you those questions. Then if it's employment based, they will ask you questions about your employer. Maybe they'll ask you how you found the job, or they'll ask you how long you've been working for. They can also ask what kind of job you do, what the job duties are. If it's an IT company, and if you're not working directly for the employer, they can ask which client you're working for and what you do there. So mostly it's about your job. And if then you go with your dependent, then your dependent will, they might ask them where they're working, but that's not really that important. More important is those questions from the 485 and their biographic. They want to verify the biographic information. They might ask questions about, some questions about the marriage. If you're going with your spouse, the dependent will be asked some questions about, they just want to make sure it's not a fraudulent marriage, but it's not a full-blown marriage-based interview kind of thing, but they might ask for some joint documents. So that's, another list. Some of the documents that I didn't mention is, if you're going with your spouse, take joint documents, joint bank accounts, a lease if you're living together, photographs, etc. As I said, it's not a full-blown marriage-based interview, but they might ask some questions to make sure that you are actually, it's a bona fide marriage. If you have kids' birth certificates, you can take those as well. So those are the questions that are asked of the dependent. It's really not much. The child, they might at the most ask them their name, date of birth maybe, depending on how old they are and which school they're going to, etc. So there's not much asked of the child. So that in a nutshell is the questions asked at the 485 interview.
Right. So Ms. Reddy, what happens once a person gets their approval? Can they travel and work?
Depends on what approval. So if they're just getting a 485 approval, then that is always followed by a green card. So the actual card is produced and sent in the mail. And until that is done, there is no proof that you're a permanent resident. So you have to wait for that green card to come in to be able to travel. You can't travel based on your 485 approval, and also to be able to work, unless you have an EAD, of course. So you have to wait for that green card. If for some reason the green card is getting delayed because it got lost in the mail or they just didn't send it, you can go to the local office, USCIS office, and you can get a I-485 stamp. That is equivalent to a green card. That's like a temporary green card. And with that, you can travel and you can work as well. So that's proof that you're a permanent resident.
Right. So, Ms. Reddy, what happens when a person's family members are in India and their I-485 is approved? Is it a problem?
Not really. As long as the marriage took place before the approval of the 485, they won't have to file a petition as, spouse of the permanent resident. That's a different family-based petition and it's not current. They will instead file a follow to join petition, which is an I-824. It's a follow to join. So basically if they are not in the country, then they'll have to file an immigrant petition. So once you file that form and it gets approved, an organization called National Visa Center will contact the petitioner who is here, the principal, or the attorney or whoever it is, and then they will ask. It's pretty much like a 485 process, but it's done, at the consulate. So, but this NVC is online. Is an organization that operates online really, and they send you emails. They ask you to upload documents online. And once you have paid the fee, which is also online, then they send the entire package to the consulate. And then the consulate will interview you for an immigrant visa petition. And then once you're interviewed and if you're approved, then they will give you a sealed envelope and they'll give you an immigrant visa. You don't have a green card as yet. You will travel to the US with that immigrant visa and you will hand over that sealed envelope to at the port of entry, and then at the port of entry they will process that green card application, and they will then, if everything is good, then they will order the card by mail, and then you'll get the green card in the mail. So that's the process if somebody's outside the country, and this is the same process if your family members are out of the country, or even if you're out of the country and you have an I-140 approved and your date is current, but you can't file a 485 because you're not in the country. This is basically the consular processing equivalent of a 485. In addition to the medicals and stuff, you'll also have to submit a police report, from your local police station, whichever country you're in, and there's a format for that, just so that they know that you have not, that you have no criminal record, and you have to go for medicals the same way. So yeah, it's a similar process, but it's just the processing time is different, the process is a little different, and it's done by a different organization.
Right. So, Ms. Reddy, what happens when an I-485 gets denied? Can that person appeal?
Yes, if it's denied, then that's the next step that you need. You can either refile if you continue to be in status, or you can appeal or file a motion to reopen. The difference is a motion to reopen, you're filing it with USCIS saying, take a second look, I think you're wrong. You came to wrong conclusion because you had the wrong facts. Or you can file an appeal, which is with a higher body, which is the Administrative Appeals Office, and say that, this officer has not applied the law properly. This is not the law. And then you can, possibly win your case on appeal. And that happens quite often. So yes, but one thing you need to know is, in order to appeal, it is time bound, so you should file your appeal within 30 days of getting your 485 denial. So whatever the date is on the denial, no matter when you get the document in hand, you have 30 days from the date of the notice to file your motion to reopen, and there is a fee involved. There is a form that has to be filled out, and then you have to submit a brief. The brief basically says why you're filing an appeal and why you think that the case should be approved. So while the appeal is pending, you can stay in the US. You're considered to be in pending status. But once the appeal, if it gets denied, if it gets accepted, then you're back to having they'll remand the case back to the USCIS, to the same office, and they will recommend that it be approved. So you're back to having a pending 485 status until they approve it. It's possible that the USCIS could then send another RFE maybe, if there's something that they have not covered, or they could just approve it. But if it gets denied, then you have to leave. And if you don't leave, it's possible that you'll be put in removal proceedings, because but this will happen only if you have no status. So for example, you've given up your H1 status, you started using your 485 EAD, so you're completely on 485 status, you don't have a non-immigrant status. Then if in such an instance your 485 gets denied, then you will really there's no other option but to leave the country. But you could leave and come back again, apply for fresh H1 and come back. That's not a problem, but
Right.
provided you get a visa. But yeah, you have to leave and come back.
Right. So, Ms. Reddy, that said, what is the difference between consular processing and adjustment of status?
So as we were discussing just now, the adjustment of status is when you're in the US, you're adjusting your status from a non-immigrant status to an immigrant status, and you're filing your 485 application with USCIS. But when you're outside the country, then you do not file your application with USCIS. Instead, the preliminary application is filed with the National Visa Center, NVC, and everything is done online. Once NVC gathers all the documents and they're satisfied that they have all the documents, they send everything to the consulate, and the consulate sends you a letter. So it's you don't get a EAD or advance parole to travel to the US if you're doing consular processing. When you're doing a 485, the advantage is you have the authority to work in the US, and you also have the ability to travel back and forth with the advance parole. With the consular processing, you have to wait for your immigrant visa petition to actually get approved. So that's one of the differences.
Right. Right. So, Ms. Reddy, the next question I'm going to ask you is kind of like a situation. So, what happens to a person who kind of moves around frequently? And what if they're afraid that the USCIS will send a package or a delivery to an address that they no longer live at? What can be done in such kind of conditions or situations?
So if you move and you have a 485 pending, it's imperative that you inform USCIS that you have moved. And they have a process in place, which is the AR11 form, which can be filled out online to inform USCIS that you have moved. But unfortunately, that's more of an obligation on your end, but USCIS does not always use that to figure out that you've moved, and they will often send it could be an approval, it could be a 765, it could be an RFE. They might send it to your old address and then it will get returned because USCIS mail doesn't get forwarded. So it's important, along with filling out the AR11, which is an obligation on your part, you should also call National Customer Service, open a service request and inform them of your change of address and get a confirmation that, by calling them again to make sure that they have your right address. This is extremely important, whether any kind of pending case that you have, to ensure you get the mail on time. Because if you don't get it on time, and if you have an RFE and then you don't even know that you have an RFE, and everything is time bound, so if you don't respond to the RFE on time, the 485 could get denied. And then, at that time, even if you have not informed USCIS of your change of address, then you cannot even file a motion to reopen because you were in the wrong. It was your obligation to inform them of the change of address and you didn't. But in some instances, you may have informed them and they still send it to the wrong address. In that case, it's complicated because you don't want to file a motion to reopen and an appeal. It just complicates and extends, the processing time of your case. But, you have to do what you have to do. So in that instance, you would then file a motion to reopen, showing proof that you actually did inform them of the change of address. So make sure you keep the proof, whatever proof you have from them, an email or whatever it is that you have, or the date that you called someone, which officer you spoke to, etc. And then you file a motion to reopen saying it wasn't my fault. So they will then hopefully send you the RFE again, reopen the case, and then, things will get back to normal.
Right. So, Mr. Reddy, thank you for giving us vivid information on that. And with that question, we come towards the end of our show. And is there any golden immigration message that you'd like to give your viewers?
What I always say, don't try to self-file. Use the help of an expert because there are a lot of little things that you may not know, and also just simple human error and typographical mistakes that you would make, which maybe a law firm, because they're trained to do this and they do it on a daily basis, may not make those as many mistakes at least as you would. So always seek expert advice whenever you're filing an application.
Right. Thank you, Ms. Reddy. It's always a privilege to host you, and we hope you have a good day. Right. So you're watching Sakshi TV Live with me, Torni Makana. Thank you.